Hello, and welcome to Picking Up the Pieces, an educational web series brought to you by Oliver Law, LLC. My name is Justin Oliver, and I am the owner and founding partner of Oliver Law. And in today's piece, I will be discussing fee and fee waivers. So if you or someone you know is involved in a Colorado family law or divorce-related legal matter, and you're concerned about coming up with the money to pay for the filing fees associated with your matter, then this is the webinar for you. The following presentation is intended to convey general legal information only and should not be taken as legal advice. The conveyance of information provided in this segment is not intended to create an attorney-client relationship, and viewers should not act upon the information provided without first seeking professional legal counsel. When parties go to file their petition and other initial paperwork needed for a divorce or dissolution in the state of Colorado, they'll be asked to pay a $230 filing fee to the court. And this is one of a number of fees related to domestic relation proceedings in the state, as you can see here on your screen. Luckily, courts recognize that it's sometimes unrealistic to expect parties with modest means to afford these amounts, so there is a process in place where indigent parties can apply for and receive a waiver of certain fees. People who are requesting a waiver of court costs for their family law or divorce-related action must complete or have completed on their behalf the motion to file without payment and supporting financial affidavit. And this is Form JDF 205, which can be downloaded for free directly from the Colorado Court's website. Now, the information on this form needs to be filled out correctly and completely. And that's because inadequate or incomplete information may result in your request to file the motion being denied, and filing fees will be assessed and all or partial payment will be expected from you. Along with the JDF 205 form, the court will also require that you provide them with copies of the previous 3 months' bank statements, including checking and savings account, and also copies of the previous 3 months' paycheck stubs or proof of income. The courts ask that you do not provide them with originals, but rather copies of these documents. When court officials review waiver applications, they are trying to determine if the applicant is indigent. And that's because a party must be considered indigent in order to have their filing fees waived. Now, an applicant is considered indigent and qualifies for a waiver of court costs in family law cases if their financial circumstances meet one of the two criteria listed there on your screen. The first being that the applicant's income is at or below the guidelines and the liquid assets are between $0 and $1,500. And the second qualifying criteria is that the applicant's income is up to 25% above the guidelines, the liquid assets of the applicant are between $0 and $1,500, and the monthly expenses are equal to or exceed the monthly income. Now, in a few moments, I'll discuss with you how to determine your income and what exactly liquid assets are. But for now, I just want you to be familiar with the guidelines and understand how they are calculated and see that they're based off family size and monthly income. Now, I had mentioned earlier that eligibility for fee waiver is based in part on income. More specifically, it's based on an applicant's gross monthly income, which takes into consideration wages, self-employment income, unemployment benefits, Social Security and SSI payments, alimony, workers' compensation, and the other forms of income that are listed here on your screen. Now, it's important to ensure that an applicant's gross monthly income is calculated accurately. And a safe way to calculate an applicant's gross monthly income is to take the hourly rate times 40 hours per week, times that by 52 weeks, and divide the whole thing by 12. Knowing what is not considered income is just as important as knowing what is considered income for fee waiver applications. Food stamps, subsidized housing assistance, VA benefits from a disability, and child support payments are not considered income. You may recall that I had mentioned earlier that in order for an applicant to fall under either of the two criteria needed to qualify for a fee waiver, the applicant's liquid assets must fall between the amounts of $0 and $1,500. For those of you who are unfamiliar with the term liquid assets, I provided a list of common liquid assets here, including cash on hand, cash in accounts, including checking and savings accounts, stock bonds, certificates of deposit, equity, and investment. And fairly liquid assets covers any personal property or investments which could be readily converted into cash without jeopardizing the applicant's ability to maintain his or her home and employment. The last topic I will be discussing under the subject of fee and fee waivers is expenses. You may recall that in order to qualify for a fee waiver under the second criteria, an applicant's monthly expenses must be equal to or exceed their monthly income. Now, expenses is a rather broad term that includes most of the costs associated with and needed to maintain an applicant's typical day-to-day necessities, like the cost of food, shelter, and transportation. Items that will not be considered as appropriate expenses for fee application purposes are your non-essential items like cable television, club memberships, entertainment, dining out, alcohol, and cigarettes. And this concludes this section of Oliver Law's Picking Up the Pieces. If you have specific questions about your Colorado family law case, I do encourage you to contact Oliver Law LLC. And don't forget to visit our website at oliverlawcolorado.com and like our Facebook page at facebook.com/Oliver Law Colorado. Until next time, my friends, this is Justin Oliver signing off for Oliver Law and the Picking Up the Pieces educational web series.